Case 1. Sametta Heyward. July 29, 2007. Charleston County, South Carolina. There are moments in the work of law enforcement that leave even the most experienced investigators searching for words. Moments where the evidence collected, the timeline reconstructed, and the facts as they exist in the official court record demand something more than professional detachment. The case of Sametta Heyward, prosecuted in Charleston County, South Carolina, beginning in the summer of 2007, became one of those moments, not only for the detectives and prosecutors who worked it, but for an entire nation that watched it unfold from a distance and could not look away. Charleston, South Carolina carries within it a deep and layered identity. It is a city of extraordinary historical weight, of antebellum architecture and centuries-old church steeples that rise above neighborhoods where generations of families have lived, worked, and built their lives. It is a city known for its hospitality, its culinary culture, its waterfront, and its community pride. But like every American city, Charleston holds within its boundaries stories that exist in painful contrast to its outward beauty. The case of Sametta Heyward is one of those stories, a case rooted not in the shadows of strangers, but inside a family home, on an ordinary summer day, with two small children whose lives ended before they had barely begun. To understand what happened on July 29, 2007, investigators and prosecutors had to first reconstruct the hours leading up to the moment everything changed. Court records from Charleston County established that Sametta Heyward was a mother of two young children. The details of their ages, their faces, their small voices. These are the details that prosecutors would later place before a jury not as abstractions, but as the human reality at the center of everything that followed. Two children, two lives. In a summer day in South Carolina when the temperature climbed into ranges that emergency medical professionals consistently describe as dangerous, life-threatening, and in cases of prolonged exposure for young children, fatal. The forensic and investigative record established through the Charleston County Court proceedings tells a story that prosecutors argued was not the result of a tragic accident, but of deliberate decisions made by the one person those two children depended on entirely for their safety and survival. According to the evidence presented at trial, Sametta Heyward left her two young children inside a vehicle on that July day while she went to work. The interior temperature of a vehicle parked in direct sunlight during a South Carolina summer can climb to levels that are lethal for young children within a time frame that investigators and medical examiners described in their testimony with clinical precision. Children's bodies regulate temperature differently than adults. Their systems are smaller, more vulnerable, and far less capable of managing extreme heat exposure. What the evidence in this case showed was that those two children were left in conditions that the medical record, and ultimately the jury, concluded were fatal. But the investigative record in the Heyward case did not end with what happened inside that vehicle. What prosecutors presented to the Charleston County jury went further, and it was the additional evidence, the evidence of what happened after, that prosecutors argued transformed this case from a tragedy into something the legal system classified as homicide by child abuse. According to the prosecution's case, when Sametta Heyward returned to the vehicle and found her children, the actions that followed were not the actions of a panicked parent calling for emergency help. The actions that followed, as reconstructed through physical evidence, witness testimony, and the findings of investigators from the Charleston County law enforcement community, were actions of concealment. Court records established that the bodies of the two children were later discovered not in a hospital, not at an emergency room, not in a location consistent with a parent who had sought help the moment they understood what had happened. They were discovered in trash bags, beneath the kitchen sink, inside the family home. This was the evidence that prosecutors placed before the jury. This was the evidence that the legal record shows became the foundation of the case against Sametta Heyward. And this was the evidence that, after deliberation, led to a conviction. The charge was homicide by child abuse. Under South Carolina law, homicide by child abuse is one of the most serious charges that can be brought in cases involving the death of a child. It does not require the prosecution to prove premeditated intent to cause death in the traditional sense. It requires the prosecution to prove that the defendant's conduct, whether through action or deliberate inaction, created conditions that caused or allowed the death of a child in their care. The jury, having heard the full weight of the evidence presented in Charleston County Court, returned a guilty verdict. The sentence handed down in the case of Sametta Heyward was 20 years in the South Carolina Department of Corrections. 20 years, a number that journalists covering the trial, victim advocates who attended the proceedings, and members of the public who followed the case through national media coverage would debate in the weeks and months that followed. There are those within the child advocacy community who believe that no sentence can adequately reflect the loss of two young lives. There are others who focus on the legal framework itself, on the fact that the system identified what happened, built a case, secured a conviction, and imposed a significant custodial sentence. What is not debated? What exists beyond argument in the public record of Charleston County, South Carolina, is that two children lost their lives, that the evidence was gathered and preserved, that the legal process ran its course, and that accountability was delivered. The Heyward case became national news not simply because of its facts, as devastating as those facts were, but because it arrived at a moment when the broader conversation about child safety, about the responsibilities of caregivers, and about the systems that exist to protect the most vulnerable members of any community, was reaching a new level of public consciousness. Advocates for child safety legislation pointed to cases like this one as evidence of the need for stronger protections, clearer legal standards, and more robust community awareness programs designed to prevent tragedies before they reach the point of criminal investigation. In the years since the verdict in the Heyward case, Charleston County has been part of a broader statewide conversation in South Carolina about child protective services, about the intersection of poverty and child welfare, and about what communities can do, beyond the reach of law enforcement, to ensure that children are safe. Organizations working in child protection across the state have cited cases from this period as turning points in how South Carolina approaches child welfare policy, mandatory reporting requirements, and community-based intervention programs. The two children at the center of this case did not have names that became nationally recognized in the way that some victims of high-profile crimes do. Their story was told primarily through the lens of their mother's prosecution. But within the Charleston community, within the child advocacy networks that operate across South Carolina, and within the court records that will remain part of the permanent public archive of Charleston County, their lives, however brief, were documented, acknowledged, and mourned. The justice system's response to their deaths was, by legal definition, an act of recognition that their lives mattered, that the law applied to them, and that the person responsible for their safety would be held accountable. What the Heyward case ultimately represents, when examined through the documentary lens of investigative journalism and legal analysis, is a case study in the catastrophic consequences of caregiver failure, and in the capacity of the American legal system, at its best, to respond to those consequences with the full weight of the law. The Charleston County prosecution of Sametta Heyward remains, nearly 2 decades later, one of the most discussed child welfare cases in South Carolina legal history. It is cited in law review articles examining the scope of homicide by child abuse statutes. It is referenced in training materials for social workers and child protective services investigators across the region. And it remains, in the memory of those who covered it and those who lived through it, a case that changed how an entire city thought about the safety of its youngest residents. For families across Charleston and across South Carolina who heard about this case when it broke, and who heard about it again when the verdict was read, it was a reminder of something that child safety advocates repeat in community forums, in legislative hearings, and in the literature of their field, that children are not capable of protecting themselves. They depend entirely on the adults around them. When that protection fails, it falls to the law to answer. In this case, the law answered. And 2 small children, who deserved so much more, were not forgotten. If you or someone you know has concerns about the safety of a child, please contact the Child Help National Child Abuse Hotline at 1-800-422-4453. Advocates are available 24 hours a day, 7 days a week. Don't forget to like this video and subscribe to Cold Case Hour for more true crime documentaries that examine the cases that changed communities forever. Case 2, Susan Smith. October 25, 1994. Union County, South Carolina. There are cases in the history of American criminal justice that do not stay within the borders of the county where they occurred. They travel. They move through the culture, through the media, through the national consciousness, and they settle into a place in the collective memory that is difficult to define but impossible to deny. The case of Susan Smith is one of those cases. Prosecuted in Union County, South Carolina, and reaching its verdict in the summer of 1995, the Susan Smith case became one of the most covered, most analyzed, and most debated criminal prosecutions of the late 20th century. Decades after the trial, the name Susan Smith remains immediately recognizable to millions of Americans who were not even alive when the events occurred. It became a case that defined an era, not only in terms of crime coverage, but in terms of how America understood the bond between a mother and her children and what it meant when that bond was broken in the most irreversible way possible. To understand the full weight of what happened in Union County in the fall of 1994, it is necessary to understand the context in which it occurred. Union, South Carolina, in the mid-1990s, was a small, tight-knit community. It was the kind of place where people knew their neighbors, where churches anchored community life, where the rhythms of daily existence were predictable and familiar. Susan Smith, 23 years old at the time, was known in that community. She worked at a local business, was involved in a relationship that had recently become complicated, and was the mother of 2 young boys. Michael Daniel Smith was 3 years old. Alexander Tyler Smith was 14 months old. They were, by every account that entered the public and legal record, healthy, cherished children, small boys with their whole lives stretching ahead of them. On the evening of October 25, 1994, Susan Smith reported to law enforcement that her car had been hijacked at a red light in Union County by an unidentified black man, who had driven away in the vehicle with her 2 sons still strapped inside. What followed was one of the largest and most emotionally charged missing child searches in South Carolina history. The story went national within hours. Susan Smith gave tearful television interviews pleading for the return of her children. The image of those 2 small boys, Michael and Alex, in their photographs, in their innocence, was broadcast across American television screens for 9 days. And then the investigation broke open. Law enforcement investigators, working methodically through the inconsistencies in Susan Smith's account, confronted her with the evidence they had gathered. On November 3, 1994, 9 days after she first reported the carjacking, Susan Smith confessed. There had been no carjacker. There had been no hijacking. What the investigation had been closing in on, what the physical evidence had been pointing toward, was this. Susan Smith had driven her burgundy Mazda to the boat ramp at John D. Long Lake in Union County, strapped her 2 sons into the vehicle, released the parking brake, and allowed the car to roll into the water. The confession sent shockwaves through Union County, through South Carolina, and through the entire country. The woman who had spent 9 days crying on national television, pleading for someone to bring her children home, had known all along where Michael and Alex were. The car was recovered from John D. Long Lake. The investigation that followed established the full timeline, the physical evidence, and the sequence of events as they had actually occurred on that October evening. The boys had been alive when the vehicle entered the water. They had been strapped into their car seats. They had not survived. The prosecution of Susan Smith in Union County became a legal proceeding of national significance. Prosecutors sought the death penalty. The defense, led by attorneys who mounted an extensive case around Susan Smith's psychological history, including a documented history of depression, a troubled childhood, and a series of deeply damaging adult relationships, argued that the full picture of her mental and emotional state was relevant to the question of culpability and sentencing. The trial itself drew international media coverage. The courthouse in Union, South Carolina, became the center of the world's attention for the duration of the proceedings. The jury convicted Susan Smith of 2 counts of murder in the first degree, but in the penalty phase, they declined to impose the death sentence. Instead, they sentenced her to life in prison with the possibility of parole after 30 years. That decision, to spare her life, generated its own wave of debate, of public commentary, of grief and anger from families and advocates who felt that the sentence did not match the magnitude of what had been done to Michael and Alex Smith. Susan Smith entered the South Carolina correctional system following her conviction. She has been the subject of ongoing public attention in the decades since, including reports of disciplinary actions within the prison system and the continuing question, as the 30-year parole eligibility mark has approached, of what accountability looks like across an entire lifetime. The legal system reached its verdict. The sentence was imposed. But the case of Susan Smith has never stopped generating questions about justice, about mental health and culpability, about how the legal system weighs the lives of victims against the circumstances of defendants, and about what communities owe to the children within them. For Michael Smith and Alexander Smith, the two little boys at the center of this case, the story is one of profound and irreversible loss. They were 3 years old and 14 months old. They were strapped into car seats on an autumn evening in South Carolina, and they did not come home. The investigation that followed their disappearance, the confession that broke the case open, the trial that played out before a national audience, and the sentence that was ultimately handed down, all of it exists in the permanent record of Union County and of American criminal justice history as an acknowledgement that their lives mattered, that what happened to them was not hidden, and that the law responded. The Susan Smith case changed how law enforcement agencies across the country approach missing child investigations. It changed how media organizations cover parental abduction claims. It contributed directly to the development of more rigorous investigative protocols for cases in which a parent is among those who report a child missing. It is taught in criminal justice programs, discussed in forensic psychology literature, and cited in policy discussions about child protection at every level of government. The legacy of this case, painful as it is woven into the fabric of how America protects children. In South Carolina, the names Michael and Alex Smith have not been forgotten. In Union County, the lake where the car was found became a place of memorial, of quiet acknowledgement, of the kind of grief that does not resolve, but that communities learn to carry. And in the broader record of South Carolina's history with child welfare and criminal justice, the case of Susan Smith stands as one of the defining moments, a moment when the entire country was forced to confront a truth that child protection advocates have always known, that the greatest threats to children's safety are not always strangers. Sometimes they come from inside the home, from within the family, from the person the child trusts most completely. The legal system in Union County delivered its answer to what happened in October of 1994. It delivered it in the form of a conviction, in the form of a life sentence, in the form of a legal record that documents every detail of the case in permanent public archives. Whether that answer is sufficient is a question that communities, advocates, and families continue to wrestle with. But the answer was given. And Michael and Alex Smith, who deserved so much more than 9 days of searching, were not forgotten. Don't forget to like this video and subscribe to Cold Case Hour, because every case we cover is a case that demands to be remembered. Case 3, Alyssa Dayvault. November 2017 and December 2018. Horry County, South Carolina. There are cases that arrive in the public consciousness quietly, that do not immediately generate national headlines or cable news coverage, but that build slowly, detail by detail, through the work of investigators and prosecutors, until the full picture comes into focus and the weight of what occurred becomes impossible to minimize. The case of Alyssa Dayvault, prosecuted in Horry County, South Carolina, across a period spanning 2 separate incidents in 2017 and 2018, is precisely that kind of case. It is a case that required methodical investigative work, careful forensic analysis, and a prosecution that had to assemble evidence from circumstances that were, by their nature, designed to remain hidden. Horry County occupies the northeastern corner of South Carolina, a sprawling coastal county best known nationally for Myrtle Beach, one of the most heavily visited tourist destinations on the Atlantic coast. Millions of people travel to Horry County each year for its beaches, its resort atmosphere, and its entertainment districts. It is, on its surface, a place defined by leisure and hospitality. But Horry County is also a permanent community of hundreds of thousands of residents, with all of the complexity, the social pressures, and the human stories that any large county carries within it. And within that community, in the area of North Myrtle Beach, the investigation into Alyssa Dayvault would reveal a set of circumstances that prosecutors, investigators, and child welfare advocates described as among the most troubling they had encountered in the region. The legal record in Horry County establishes that Alyssa Dayvault was charged in connection with the deaths of 2 newborn infants. The 2 incidents occurred at separate times, the first in November of 2017, the second in December of 2018. In both cases, The evidence presented by prosecutors established that Dayvault had experienced pregnancies that she concealed from those around her. In both cases, the infants were delivered at home. In both cases, the infants were born alive. And in both cases, the evidence showed that the infants did not receive medical care, did not survive, and were placed in trash bags and discarded. The investigation into these cases required the kind of careful forensic work that is central to cases where the primary evidence involves the recovery and examination of remains discovered in circumstances that make establishing a clear chain of events both critical and complex. Investigators working in Horry County, alongside forensic specialists, worked to establish through the physical and medical evidence the facts that would ultimately support the prosecution's case, that the infants were born alive, that they had been viable, and that the circumstances of their deaths were connected to decisions made by Alyssa Dayvault. The legal proceedings in Horry County resulted in a conviction that carried one of the most significant sentences handed down in a case of this type in South Carolina history at the time. Alyssa Dayvault received 2 consecutive 40-year prison sentences, 80 years in total, for the 2 counts of homicide by child abuse. The sentence reflected the severity of what the evidence had established, not a single incident, but a pattern. Not one concealed pregnancy and one set of decisions made in a moment of crisis, but 2. The jury and the court found that the evidence supported a finding that what occurred in 2017 was not an isolated tragedy, but was followed, a year later, by the same outcome, and that the legal system's response had to reflect that full factual record. The Dayvault case prompted significant discussion in Horry County and across South Carolina about the circumstances that lead to neonaticide, the term used in forensic and legal literature for cases involving the death of a newborn infant within the first hours of life. Researchers, public health professionals, and legal scholars have spent decades studying this phenomenon, attempting to understand the complex web of psychological, social, and situational factors that contribute to these cases. What that body of research consistently finds is that these cases do not occur in a vacuum, that they are often connected to profound social isolation, to a fear of disclosure, to circumstances in which a person facing an unplanned or unwanted pregnancy feels that there is no available path to safety or help. That context does not alter the legal findings in the Dayvault case. The court in Horry County heard the evidence and imposed a sentence that reflected the gravity of what the evidence showed. But it does speak to the broader conversation that child welfare advocates, public health officials, and legal scholars have continued to have in the years since this case concluded, about how communities can create conditions in which people facing crisis pregnancies have access to support, to medical care, to legal alternatives, and to the kind of help that might prevent tragedies of this kind before they reach the point of criminal investigation and prosecution. Safe haven laws, which exist in every state in the United States including South Carolina, are designed specifically to address the circumstances that cases like the Dayvault case bring into focus. Under South Carolina's safe haven law, a parent facing a crisis situation with a newborn can surrender the infant to designated locations, hospitals, fire stations, and other safe havens, without criminal prosecution, provided the infant is unharmed and the surrender occurs within a defined period of time after birth. These laws exist because the public health and legal communities recognized, through the careful study of cases like this one, that legal alternatives to tragedy are possible, but only if people know they exist and believe they can access them without fear. In the aftermath of the Dayvault prosecution, child welfare organizations in South Carolina increased their public awareness efforts around safe haven provisions, distributing information through healthcare providers, community organizations, and public media campaigns designed to ensure that anyone facing the kind of crisis that underlies cases like this one knows that there is a legal, protected path to safety for both the parent and the child. The case of Alyssa Dayvault, in that sense, became not only a legal proceeding but a catalyst for community action, an example of the way in which the most painful cases can, if communities respond thoughtfully, generate something constructive in their aftermath. For the 2 infants at the center of this case, whose lives were counted in hours, whose existence became known to the wider world only through the investigative and legal record of Horry County, the documentary record ensures that they were not simply erased. The investigation found them. The prosecution named them, in the context of a legal proceeding, as human beings whose lives had value and whose deaths required accountability. The sentence imposed on Alyssa Dayvault stands in that record as a legal acknowledgement of their worth. The case of Alyssa Dayvault remains one of the most heavily discussed child welfare prosecutions in Horry County's legal history. It is referenced in discussions about safe haven law awareness, in child protective services training programs, and in the broader literature on neonaticide cases in the American legal system. Its legacy, painful as it is, includes the community responses it generated, the increased awareness, the expanded outreach, and the conversations it forced communities across South Carolina to have about what it means to create conditions in which every child has the opportunity to survive. Don't forget to like this video and subscribe to Cold Case Hour. Every story we tell is a story that deserves to be told, and a community that deserves to know the truth. Case 4, Sara Shakeri-Taylor. May 15, 2024. Charleston County, South Carolina. There are cases that arrive in the investigative record carrying layers of evidence that extend far beyond the central facts of the case itself. Cases where what investigators find when they begin to look closely reveals not just one dimension of harm, but multiple. The case of Sara Shakeri-Taylor, charged in Charleston County, South Carolina, in connection with events that occurred on May 15, 2024, is precisely that kind of case. It is a case that, from the moment investigators entered the residence in Latson, in Charleston County, began to reveal evidence that went beyond what any initial response call might have anticipated. And it is a case that, as it moved through the Charleston County legal system, placed in sharp relief the devastating intersection of the ongoing fentanyl crisis and the safety of the most vulnerable members of any community, its youngest children. Charleston County, which encompasses not only the historic city of Charleston, but the surrounding municipalities including Latson, North Charleston, and a broad geography of communities that make up one of South Carolina's largest and most populous counties, had been tracking the impact of the fentanyl crisis across its communities for years before the Shakeri-Taylor case emerged. Law enforcement agencies, emergency medical services, hospitals, and public health officials across the county had all documented the rising presence of fentanyl in the community, in drug seizures, in overdose statistics, in the emergency room data that tells a community how its public health landscape is changing. What the Shakeri-Taylor investigation brought into focus was a dimension of that crisis that investigators described as among the most alarming they had encountered: a 10-month-old infant in a Charleston County home, fatally exposed to fentanyl. The investigative record in this case, as established through the Charleston County court proceedings, begins on May 15, 2024, when emergency responders were called to the residence in Latson. What they found when they arrived, and what investigators documented in the hours and days that followed, was a scene that generated one of the most detailed and disturbing evidentiary records in a child welfare prosecution in Charleston County in recent years. The infant, 10 months old, had not survived. The cause, as established by the medical examiner and presented in the court record, was connected to lethal fentanyl exposure. But the physical evidence documented at the scene extended far beyond what was directly connected to the infant. Investigators found baby bottles that tested positive for fentanyl, a pacifier that tested positive for fentanyl, currency, cash, that tested positive for fentanyl. The presence of that evidence in the space where a 10-month-old child lived, in the objects that a 10-month-old child would have routinely encountered and placed in their mouth, established, in the investigators' analysis, a picture of an environment in which the presence of fentanyl was not an isolated or accidental occurrence, but a pervasive feature of the household. The ordinary objects of infant care, the bottles, the pacifier, had become vectors of lethal exposure. And the evidence did not stop there. Investigators also documented evidence of an illegal dogfighting operation on the property. The combination of evidence, the fentanyl contamination of infant care items, the illegal animal fighting operation, painted a portrait of a household environment that investigators characterized as one of sustained and serious disregard for safety. The legal standard in Charleston County, as in all South Carolina jurisdictions, for homicide by child abuse requires evidence that the circumstances in the child's environment were sufficiently dangerous that a reasonable person would have recognized the risk to the child's life. The evidence gathered at the Latson residence was, in the prosecution's framing, evidence that spoke directly to that standard. Sara Shakeri-Taylor was charged with homicide by child abuse in connection with the death of her 10-month-old infant. The case remained pending in the Charleston County legal system as of the time this documentary was produced, with the full adjudicatory process ongoing. What the charging documents and the investigative record establish, as a matter of public legal record, is that investigators and prosecutors in Charleston County found sufficient evidence to support the charge, and that the evidence they found went far beyond the immediate circumstances of the infant's death to encompass the broader environment in which that child was living. The Shakeri-Taylor case arrived at a moment when communities across South Carolina and across the country were grappling with how to address the fentanyl crisis in the context of child safety and child protection. The evidence gathered in this case, the contaminated bottles, the contaminated pacifier, the contaminated currency, became part of a larger conversation in child protective services and law enforcement circles about how to assess fentanyl exposure risk to children in households where the drug is present. Pediatric medical professionals and forensic toxicologists have noted that infants and very young children face dramatically elevated risks of serious harm from fentanyl exposure compared to adults, both because of the difference in body weight and because of the routes of exposure that are unique to infants, including the routine mouthing of objects in their environment. Child welfare organizations in South Carolina, in the wake of this case, reinforced their guidance to mandatory reporters, teachers, healthcare providers, childcare workers, and others who are legally required to report suspected child abuse about the signs of drug exposure in infants and the appropriate reporting protocols when those signs are present. The case served as a stark reminder that in a community navigating a fentanyl crisis, the youngest and most defenseless members of that community are at risk in ways that are not always immediately visible, but that can be catastrophic when they go unaddressed. For the 10-month-old infant at the center of this case, a child who was 10 months old, who had not yet had the chance to walk, to speak, to experience the world in any meaningful way beyond the household where they spent every hour of their brief life. The Charleston County legal proceeding represents the formal, public acknowledgement that what happened to them was not acceptable, not invisible, and not without consequence. The charge filed against Sara Shakeri-Taylor stands in the court record as a statement that the law of South Carolina applies to every child, regardless of the circumstances of their household, and that the legal system will respond when that protection fails. The broader community in Charleston County, the parents, the neighbors, the educators, the healthcare workers, the child welfare advocates who read about this case in the local news, responded to the Shakeri-Taylor case with the kind of grief and determination that cases of this magnitude tend to generate. The grief, because a child lost their life. The determination, because communities that engage seriously with these cases do not simply mourn, they act. They strengthen reporting networks. They improve outreach. They ensure that the lessons embedded in the evidence of each case are used to protect the next child who might otherwise be at risk. Don't forget to like this video and subscribe to Cold Case Hour, where we document the cases that communities cannot afford to forget. Case 5, Alexis Grant. May 11, 2017. Charleston County, South Carolina. The cases that arrive in the investigative record of any law enforcement agency with the most devastating impact are often the cases that involve the youngest victims, children whose lives, measured in months rather than years, ended in circumstances that left even seasoned investigators searching for the words to describe what they had found. The case of Alexis Grant, prosecuted in Charleston County, South Carolina, in connection with events that occurred on May 11, 2017, in North Charleston, is one of those cases. It is a case built on physical evidence, on investigative findings, and on a legal admission that placed on the record of Charleston County one of the most direct and unambiguous accounts of harm to a child that the court system had processed in years. North Charleston, South Carolina, is the largest city in Charleston County by population, a city with its own distinct identity, its own community institutions, its own history, and its own challenges. It is a city where law enforcement, social services, healthcare providers, and community organizations work in a complex and demanding environment to serve a large and diverse population. And it is a city where, on a day in May of 2017, a 1-year-old child named Caden Grant was brought to the attention of investigators under circumstances that initiated one of the most straightforward and yet most heartbreaking prosecutions in the county's recent history. The investigative record in this case, as established through the Charleston County Court proceedings, begins at an area hotel in North Charleston. The specific location, a hotel room, is significant in the context of the case because it is a setting that speaks to the circumstances in which this young child and his mother were living at the time. Investigators responding to the scene found a 1-year-old child who had sustained injuries that the medical record described in terms that, in the documentary framing appropriate for a case of this sensitivity, can be accurately characterized as severe and consistent with significant force having been applied to a small child's body. The injuries documented by medical personnel and forensic investigators included harm to the skull, bruising across the body, and injuries to the rib structure. Injuries that, in the context of a 1-year-old child, represent a profound and irreversible violation of a small person who had no capacity to protect himself. Caden Grant did not survive his injuries. The investigation that followed moved with a directness that, in the legal record, is explained by what Alexis Grant told investigators. The court record establishes that she admitted to striking her son in the head, not once, but repeatedly, out of frustration. That admission, provided to investigators and formalized in the legal record of the case, became the foundation of the prosecution's case in Charleston County. There was no dispute about what had happened. There was no alternative theory of the crime. There was an admission, documented in the investigative record, that a mother had struck her 1-year-old son in the head with sufficient force to cause injuries that resulted in his death. Alexis Grant was charged with homicide by child abuse. She entered a guilty plea to the charge in Charleston County Court, a decision that, in the legal structure of the case, meant that the full evidentiary record was accepted as factually established without the need for a trial. The guilty plea is a formal legal acknowledgement, not simply a procedural step, but a moment in which the defendant, before the court and the public record, accepts the facts as presented by the prosecution. In this case, that meant accepting that the injuries documented at the North Charleston hotel room and the death of Caden Grant were the result of her actions. The sentence imposed on Alexis Grant was 20 years in the South Carolina Department of Corrections. 20 years for the life of a 1-year-old child who had barely had the chance to exist. Child welfare advocates who followed the case noted the sentence as a reflection of the seriousness with which the Charleston County court system treated the charge of homicide by child abuse, a charge that, in South Carolina, carries a mandatory minimum sentence and reflects the legislature's determination that the deaths of children in the care of their caregivers must be treated with the full weight of the criminal law. The Grant case arrived at a time when communities across Charleston County were engaged in an ongoing and difficult conversation about the intersection of poverty, housing instability, parental stress, and child safety. The hotel room setting in this case, a detail that legal commentators and social workers who followed the case noted as significant, spoke to a set of circumstances that child welfare researchers have consistently identified as elevating risk factors for children: residential instability, economic pressure, social isolation, and the absence of the support networks that help parents manage the inevitable stresses of caregiving. None of these circumstances constitute a legal defense, as the guilty plea in this case made clear. But they are circumstances that communities committed to preventing future tragedies cannot afford to ignore. Child welfare organizations in North Charleston and across Charleston County have, in the years since this case, worked to expand access to crisis intervention services for parents experiencing the kind of acute stress that the Grant case brought into focus. Hotlines, respite care programs, community-based family support services, and emergency housing assistance are all resources that child protection advocates have identified as critical components of a prevention infrastructure designed to reach families before the circumstances that lead to tragedies like Caden Grant's death can fully develop. The lesson embedded in the evidence of this case is not only about accountability, it is also about the systems that communities build or fail to build to protect children before the need for criminal prosecution arises. For Caden Grant, 1-year-old, brought to a hotel room in North Charleston in May of 2017 and never given the chance to grow beyond that moment. The legal record of Charleston County stands as a formal acknowledgement that his life had value, that what happened to him required a legal response, and that the system applied the law to the person responsible for his care and for his death. He was 1 year old. He deserved to grow up. The court record of Charleston County says, in the formal language of the law, that what was done to him was wrong, that it was criminal, and that it would not go without consequence. Don't forget to like this video and subscribe to Cold Case Hour. Caden's story, and the stories of all the children in this documentary, deserve to be remembered. Case 6, Cynthia Estrada-Lopez. July 2017. Lexington County, South Carolina. Among all of the cases examined in this documentary, there are those that carry within them a dimension of suffering that extends not simply to the moment of the crime, but across a period of time that investigators and prosecutors described in their legal filings with language that reflects a level of sustained harm that is, by any standard of human decency, almost impossible to fully absorb. The case of Cynthia Estrada-Lopez, prosecuted in Lexington County, South Carolina, in connection with events that occurred in July of 2017, is one of those cases. The victim was 4 years old. Her name was Lily Lopez, and the evidence that the Lexington County prosecution placed on the record described a set of circumstances that resulted in one of the longest sentences imposed in a South Carolina homicide by child abuse case in recent memory. Lexington County sits in the heart of South Carolina, immediately west of the state capital of Columbia. It is a county of growing communities, suburban neighborhoods, and established residential areas where families have lived for generations. It is also a county whose law enforcement and judicial systems have, over the years, processed a range of child welfare cases that have contributed to the ongoing conversation in South Carolina about child protection, mandatory reporting, and the legal standards applied to cases of severe harm to children. The case of Cynthia Estrada-Lopez became one of the most significant of those cases, not only because of the length of the sentence imposed, but because of the nature of the evidence that the prosecution presented to establish what had happened to 4-year-old Lily Lopez. The court record in Lexington County establishes that Lily Lopez, 4 years old, lost her life in circumstances that investigators characterized as involving restraint and suffocation. The prosecution presented evidence that Lily had been restrained to her bed using tape, that her movements had been deliberately restricted in a manner that prevented her from moving freely. The prosecution further presented evidence that tape had been applied to the child's mouth, creating a condition of airway obstruction that ultimately resulted in suffocation. Lily Lopez, 4 years old, did not survive. The cause of death, as established by the medical examiner and presented in the Lexington County court record, was consistent with the evidence of suffocation that investigators had documented. The physical evidence gathered from the scene, the medical findings, and the overall evidentiary record supported a charge of homicide by child abuse, a charge that Cynthia Estrada-Lopez ultimately resolved through a guilty plea. That guilty plea, like the one in the Alexis Grant case, represents a formal legal acknowledgement that the facts as presented by the prosecution were accurate, that the evidence gathered by Lexington County investigators told the true story of what happened to Lily Lopez. The sentence imposed on Cynthia Estrada-Lopez was 38 years in prison without the possibility of parole. 38 years, without parole, a sentence that reflects the Lexington County Court's assessment of the severity of what the evidence showed, and that reflects the South Carolina legislature's determination, embedded in the statutory framework for homicide by child abuse, that cases involving the deliberate and severe harm of young children in the care of their caregivers warrant some of the most serious sanctions available under state law. The no parole provision is significant. It means that Cynthia Estrada-Lopez will serve the full 38 years in the South Carolina correctional system, without the possibility of early release through the parole process. For child welfare advocates, the sentence in the Estrada-Lopez case was notable not only for its length, but for what it communicated about the court system's response to evidence of sustained harm to a child. Cases that involve a single, acute event, however terrible, are, in some respects, legally and emotionally different from cases that involve evidence of circumstances in which a child was subjected to conditions that prevented their ability to seek help, to escape, or to survive. The evidence in the Estrada-Lopez case, the restraint, the tape, the conditions documented by investigators, spoke to circumstances that the court found warranted the maximum available response within the statutory framework for this charge. The case of Cynthia Estrada-Lopez and the death of Lily Lopez prompted a renewed examination in Lexington County and across the surrounding region of the systems in place to identify children at risk. 4-year-olds, unlike infants, are old enough to have contact with the outside world, with neighbors, with childcare settings, with pediatric healthcare providers, with community members who might encounter them in the course of daily life. The question that child welfare advocates, social workers, and community members wrestled with in the wake of this case was, what systems need to be in place, and what awareness needs to exist in communities to ensure that when a child is in danger, there are people around who recognize it and who know how to act? Mandatory reporting laws in South Carolina require a broad range of professionals, including teachers, childcare workers, healthcare providers, law enforcement officers, and others, to report suspected child abuse to the appropriate authorities. But mandatory reporting is only as effective as the awareness and training that support it. Organizations working in child protection across Lexington County and the state have, in the years since the Estrada-Lopez case, worked to strengthen that training, to ensure that the professionals who work with children understand not only their legal obligations, but the specific indicators of harm that can alert them to a child who needs help. Lily Lopez was 4 years old. She had a name. She had a face. She had, as every 4-year-old does, the full force of her own personality, her own curiosity about the world, her own claim on a future that she never received. The legal record of Lexington County acknowledges her. The sentence imposed on Cynthia Estrada-Lopez acknowledges her. And this documentary, in telling her story with the care and the seriousness it demands, is part of the broader project of ensuring that her name is not forgotten, that what happened to her is understood, and that the systems designed to protect children like her continue to improve in her memory and in the memory of every child whose story is told in these archives. Don't forget to like this video and subscribe to Cold Case Hour. Lily's story matters. Every story matters. Case 7, Joyce Renee Stover. October 30th, 2021. Chester County, South Carolina. The intersection of the national fentanyl crisis and child welfare is one of the defining public health and legal challenges of the current era in American history. Across every state, in every type of community, urban and rural, large and small, wealthy and economically distressed, law enforcement agencies, child protective services investigators, prosecutors, and pediatric healthcare providers have been grappling with the consequences of fentanyl's presence in homes where children live. The case of Joyce Renee Stover, prosecuted in Chester County, South Carolina, in connection with events that occurred on October 30th, 2021, places that intersection in the starkest possible terms. An 11-month-old child. A lethal dose of fentanyl. A conviction and a 35-year sentence that the Chester County court system delivered as its formal response to what the evidence showed. Chester County sits in the northern tier of South Carolina, a primarily rural county with a county seat in the town of Chester. It is a community with deep historical roots, with strong local institutions, and with the particular set of challenges that many rural South Carolina counties share: economic pressures, limited access to certain healthcare and social services, and a documented impact from the opioid and fentanyl crisis that has reshaped the public health landscape across much of rural America. The case of Joyce Renee Stover emerged from that landscape, from the circumstances of a household where an 11-month-old infant was in the care of a person who, the prosecution argued, allowed a lethal exposure to occur. The legal record in Chester County establishes that Joyce Renee Stover's 11-month-old infant was found unresponsive on October 30th, 2021. The medical and toxicological findings in the case established that the cause of the infant's death was acute fentanyl toxicity, that the child had ingested a lethal quantity of fentanyl. In a child of 11 months, the margin between any exposure and a lethal dose is extraordinarily small. Fentanyl is, by every measure in the forensic and medical literature, among the most potent and dangerous synthetic opioids ever produced. In adult users, it carries a high risk of fatal overdose even at doses that are measured in micrograms. In infants, the risk profile is categorically different. Any exposure to fentanyl represents a potentially fatal event, and there is no threshold below which exposure can be described as safe. The prosecution's case in Chester County argued that the circumstances of this exposure were not accidental in any meaningful legal sense, that Joyce Renee Stover's conduct in the period leading up to October 30th, 2021, including her violation of safety restrictions that had been placed on her through prior legal proceedings, constituted the kind of reckless disregard for her infant's safety that met the legal standard for homicide by child abuse. The existing safety restrictions that the prosecution referenced were a specific and significant element of the case. They established that this was not a situation in which a parent was encountering the risks posed by fentanyl for the first time, without any prior warning or legal intervention. The restrictions had been put in place. They had not been followed, and an 11-month-old child had died as a result. Joyce Renee Stover was convicted of homicide by child abuse following the Chester County proceedings. The sentence imposed was 35 years in the South Carolina Department of Corrections. The sentence, like those imposed in the other cases examined in this documentary, reflects the statutory framework that the South Carolina legislature has built around the charge of homicide by child abuse, a framework designed to communicate, in the clearest possible legal terms, that the deaths of children in the care of their caregivers, when connected to the caregiver's conduct or failure to protect, carry consequences that are among the most severe available under South Carolina law. The Stover case became part of a broader discussion in Chester County and across the state about what the legal system can and cannot do to protect children in households where fentanyl is present. Law enforcement agencies, child protective services investigators, and prosecutors across South Carolina have worked in the years since this case to develop more coordinated approaches to exactly this problem, to ensure that when children are identified as living in households where fentanyl use or distribution is present, the full range of legal and child welfare tools is deployed to assess and address the risk to those children. That coordination involves not just criminal law enforcement, but civil child welfare proceedings, family court interventions, and community-based support services that can provide alternative arrangements for children whose safety cannot be assured in their current living environment. The pediatric medical community has also been active in this space, developing protocols for the identification of fentanyl exposure in infants and children, training emergency room staff and pediatric nurses to recognize the signs of opioid exposure in young patients, and working with child protective services to ensure that medical findings are communicated to the appropriate authorities in a timely manner. These protocols, developed in part in response to the pattern of cases that emerged across the country as the fentanyl crisis deepened, represent the medical community's contribution to the broader child protection infrastructure that every community needs to keep its youngest members safe. For the 11-month-old infant at the center of the Stover case, a child who was 11 months old, who had just begun to experience the world, who had never had the chance to walk or talk or grow up, the legal record of Chester County, South Carolina, stands as a formal acknowledgement that their life had value, that the law applied to their death, and that the court system of their county responded with the full weight of the law. 35 years is the Chester County Court's answer to what the evidence showed. It is an answer delivered on behalf of a child who was too young, too small, and too vulnerable to speak for themselves. In South Carolina, as in every state grappling with the fentanyl crisis, the conversation about child safety and drug exposure continues. Every case that comes through the legal system, every conviction, every sentence, every documented set of facts in the evidentiary record adds to the body of knowledge that communities, lawmakers, healthcare providers, and child protection advocates use to sharpen their responses and strengthen their systems. The Stover case is part of that record, and the 11-month-old child whose death it documents is part of a broader legacy of loss that communities across this country have committed themselves to preventing. Don't forget to like this video and subscribe to Cold Case Hour. We tell these stories because the children in them deserve to be remembered, and because communities committed to their safety need to know the truth. Case 8, Brennan Hailey Geller. August 3, 2018. Lexington County, South Carolina. There are cases in the legal record that challenge communities and legal systems to grapple simultaneously with multiple dimensions of harm, with the physical facts documented by investigators and medical examiners, with the circumstances that preceded the event, and with the broader questions of what was known, what was visible, and what went unaddressed in the period before the case came to law enforcement's attention. The case of Brennan Hailey Geller, charged in Lexington County, South Carolina, in connection with events that occurred on August 3, 2018, is one of those cases. It is a case involving a newborn child, a child born alive, under circumstances that the investigation established were known to the defendant and unknown to everyone else, and a sequence of decisions made in the hours immediately following that birth that resulted in a charge of homicide by child abuse. Lexington County, which had already appeared in this documentary in the context of the Cynthia Estrada-Lopez case, is a community that has processed multiple high-profile child welfare cases through its legal system. Its courts, its law enforcement agencies, and its child protective services system have developed experience with the range of circumstances that lead to the most serious child abuse prosecutions. The Geller case arrived in that legal system with a set of facts that were, in certain respects, unlike any that had previously come before Lexington County courts in recent memory, and that required investigators to reconstruct a timeline from physical evidence, medical records, and the circumstances of the defendant's own hospital admission. The legal record in this case establishes that on August 3, 2018, Brennan Hailey Geller gave birth to a baby girl inside her car. The birth occurred in the vehicle, a circumstance that, while rare, is not unknown in emergency medical contexts, typically in situations where a mother in labor was unable to reach a medical facility in time. But what the investigation in this case established was that the birth was not an emergency that caught Geller by surprise in the way that such events typically unfold. The pregnancy, the investigation found, had been concealed. What happened after the birth is what the Lexington County prosecution placed at the center of its case. According to the evidence presented, Geller wrapped the live newborn in a black plastic trash bag and placed the infant on the floorboard of the vehicle. She then drove home. The investigation established that the newborn was alive when it was placed in the trash bag, and that the circumstances of being wrapped in a plastic bag represented a condition that was not compatible with the infant's survival. The infant did not survive. The case came to the attention of investigators not through a direct discovery of the infant at the scene, but through the circumstances of Geller's own medical situation. She subsequently went to a hospital for treatment of severe blood loss, a condition consistent with having given birth. When she arrived at the hospital, she did not disclose to medical staff that she had delivered a baby. It was the investigation initiated in response to her hospital admission and the medical evidence of recent delivery that led investigators to the vehicle and to the infant. The recovery of the infant from the vehicle and the subsequent forensic and medical analysis established the core facts that supported the charge of homicide by child abuse in Lexington County. The physical evidence, the trash bag, the location on the vehicle floorboard, the condition in which the infant was found, was consistent with the prosecution's account of what had occurred. The medical evidence of the infant's condition at the time of death contributed to the evidentiary record, and the circumstances of Geller's hospital admission, the concealment of the delivery from medical staff, the absence of any attempt to seek help for the infant, completed the picture that prosecutors presented to the court. The Geller case, like the Dayvault case examined earlier in this documentary, falls within the category of cases involving neonaticide, a phenomenon that public health researchers, forensic psychologists, legal scholars, and child welfare advocates have studied extensively, recognizing it as a distinct and complex set of circumstances that differs, in important respects, from other forms of harm to children. The research literature on neonaticide consistently identifies concealed pregnancy as the primary context in which these cases occur, and identifies a cluster of social, psychological, and situational factors that tend to accompany concealed pregnancy. Fear of disclosure to family members or partners, social isolation, the absence of perceived alternatives, and, in some cases, significant psychological distress. That literature does not alter the legal findings in the Geller case. The Lexington County legal system assessed the evidence, applied the law, and made a determination about the charge and the appropriate legal response. What the literature does is provide communities with a framework for understanding the conditions under which these tragedies occur, and for building prevention infrastructure that can reach people in crisis before the events that lead to criminal prosecution. South Carolina's safe haven law is the most direct legal tool available for addressing the circumstances that underlie cases like Geller's. Under that law, a parent in a crisis situation with a newborn infant can surrender the child to a designated safe haven location, a hospital, a fire station, a law enforcement facility, without criminal prosecution, provided the infant is unharmed and the surrender occurs within a legally defined period. The law exists precisely because legislators, informed by research and by the public record of cases like this one, recognized that creating a legal pathway to safety was the most effective way to prevent neonatal. Don't forget to like this video and subscribe to Cold Case Hour. Every child in these cases deserves to be remembered. Every story deserves to be told. Case 9, Tamika Yolanda Williams. May 23, 2018. Charleston County, South Carolina. There are moments in criminal proceedings when the facts of a case, as presented in the court record, strip away every layer of complexity and present the legal system, and the community watching it, with a question of extraordinary simplicity and extraordinary weight. At the moment when a child needed help, was help given? In the case of Tamika Yolanda Williams, charged in Charleston County, South Carolina, in connection with events that occurred on May 23, 2018, in North Charleston, the answer to that question is documented in the legal record with a precision and a directness that leaves little room for ambiguity. A 3-day-old infant. An act of physical harm. 20 minutes. And a child who sustained injuries that the medical record established were fatal. The Williams case arrived in the Charleston County legal system carrying the particular weight of all cases involving newborns. Children who are, by definition, at the extreme end of human vulnerability, whose survival depends entirely and completely on the adults responsible for their care. A 3-day-old infant has no capacity whatsoever for self-protection, for communication beyond the signals of distress that are accessible to any attentive caregiver, or for survival independent of deliberate and continuous adult care. When harm comes to a child of 3 days old, it comes to someone who cannot defend themselves, cannot call for help, and cannot survive the absence of immediate medical intervention. The legal record in this case, as established through the Charleston County Court proceedings, begins in North Charleston on May 23, 2018. Tamika Yolanda Williams, the mother of a 3-day-old newborn, admitted in the investigative record to deliberately dropping the infant to a carpeted floor during a moment of frustration. The admission is documented in the court record. It establishes, in the defendant's own words, that the act was deliberate, not an accidental drop, not a momentary loss of physical control, but a deliberate act. The legal significance of that distinction is foundational to the homicide by child abuse charge. The standard requires evidence that the harm was the result of conduct that created a substantial risk of death or serious bodily injury to the child. But the legal record also establishes the second dimension of this case, a dimension that many child welfare advocates and legal commentators have pointed to as equally important as the initial act in understanding the full scope of the harm. After dropping the infant, Tamika Williams waited approximately 20 minutes before calling for emergency medical assistance. 20 minutes in which the infant, who had sustained traumatic brain injuries as a result of the fall, received no medical intervention. 20 minutes in which a 3-day-old child, injured and unable to communicate the nature or severity of their distress, lay without the emergency medical care that might have altered the outcome. The forensic and medical record in this case established that the infant sustained fatal brain injuries as a result of the fall. The traumatic brain injury sustained by a 3-day-old child from a deliberate drop, combined with the delay in accessing emergency medical care, created the circumstances that the prosecution in Charleston County argued, and the legal record supports, met the standard for homicide by child abuse. Tamika Yolanda Williams was charged with that offense. The Williams case opened a discussion in North Charleston and across Charleston County about the intersection of postpartum mental health and child safety, a discussion that pediatric and maternal health professionals, social workers, and child welfare advocates have been engaged in nationally for years, but that, in the specific context of this case, took on particular urgency. The period immediately following childbirth is, for many people, one of the most psychologically intense and physiologically demanding periods of human life. The medical and psychological literature on postpartum mental health is extensive, well documented, and broadly accepted within the healthcare community. Postpartum depression and postpartum anxiety affect a significant percentage of new parents, and in a subset of cases, postpartum mental health challenges can manifest in forms that are severe and that require immediate clinical intervention. None of the documented research on postpartum mental health removes legal accountability for acts of harm committed against newborns. That is not the purpose of this discussion, and it is not the framework that the Charleston County legal system applied to the Tamika Williams case. What the discussion of postpartum mental health does do, what it is intended to do, in the context of this documentary, is point communities toward the prevention infrastructure that exists to reduce the likelihood that a new parent in crisis will reach a moment of harm. Crisis hotlines for new parents. Postpartum mental health screening programs in obstetric and pediatric settings. Hospital-based support services for new mothers before discharge. Community health worker programs that follow up with new parents in the weeks after birth. All of these are resources that exist in various forms across Charleston County and South Carolina, and all of them represent points of potential intervention in cases where a new parent is experiencing a level of distress that puts themselves or their child at risk. For the 3-day-old infant at the center of this case, a child who was only 3 days into their life when the events of May 23, 2018, occurred. The Charleston County legal record represents the formal acknowledgement that what happened to them was not acceptable, not without consequence, and not hidden from the legal record that documents what occurs in communities. Tamika Yolanda Williams faced the Charleston County legal system in response to what the investigation established. The 3-day-old child whose death initiated that investigation was, in the language of the legal system, a victim entitled to the full protection of South Carolina law. If you or someone you know is experiencing a mental health crisis related to pregnancy or the postpartum period, please know that help is available. The Postpartum Support International Helpline can be reached at 1-800-944-4773. Support is available for all new parents. You are not alone, and help is always available. Don't forget to like this video and subscribe to Cold Case Hour, because every story we tell exists so that the next child can be protected. Case 10. Jamie Michele Bradley-Brun. May 19, 2023. Beaufort County, South Carolina. There are cases that conclude a documentary not because they are the oldest or the most widely known, but because they carry within them, in the starkest possible terms, the full weight of everything that has come before them. All of the questions about protection, about accountability, about what the legal system owes to children, and about what communities owe to the most vulnerable people within them. The case of Jamie Michele Bradley-Brun, sentenced in Beaufort County, South Carolina, in connection with events that occurred on May 19, 2023, at St. Helena Island, is that kind of case. It is a case involving 2 children, a 6-year-old and an 8-year-old, and events inside a family home that ended with a 50-year prison sentence and with the survival, against all odds, of one child who made the decisions and took the actions that ultimately brought law enforcement to the scene. St. Helena Island, part of Beaufort County in the South Carolina Lowcountry, is one of the most historically significant places in the American South. It is part of the Sea Islands chain, a geography with a distinctive cultural heritage and a community with deep roots in the traditions and history of the Gullah Geechee people. It is a place of extraordinary natural beauty, of marshland and maritime forest, of a pace and character that distinguish it from the more densely developed parts of the South Carolina coast. It is also a place where, on a May evening in 2023, inside a family home, events occurred that resulted in one of the most severe sentences handed down in a South Carolina child welfare case in the current decade. The legal record in Beaufort County establishes that on May 19, 2023, Jamie Michele Bradley-Brun took her 6-year-old daughter into a bathroom in the family home and submerged her in the bathtub with fatal intent. The 6-year-old child did not survive. The court record further establishes that Bradley-Brun attempted to subject her 8-year-old daughter to the same fate in the same setting. The 8-year-old survived because she acted. The court record documents that the 8-year-old child, placed in a situation of immediate danger, managed to escape from the bathroom. Having escaped, she did not hesitate. She went immediately to contact a relative, a decision that, in the clarity of retrospect, saved her life, and brought law enforcement to the scene. The relative received the child's communication and called law enforcement immediately. Officers responded to the St. Helena Island home. What law enforcement found when they arrived, and what the subsequent investigation established in the Beaufort County legal record, formed the basis of one of the most significant prosecutions in that county's recent history. The evidence gathered at the scene, the testimony developed through the investigative process, and the full account of what had occurred on May 19, 2023, supported a charge that resulted in a conviction and the 50-year sentence that was ultimately handed down. 50 years. For child welfare advocates, for legal commentators, for the community in Beaufort County that followed this case, and for the broader public in South Carolina that was watching the legal system respond to the events of that May evening, the sentence was the court's statement, unambiguous, on the record, and measured in decades, about the gravity of what the evidence had shown. 50 years reflects a determination that what happened on St. Helena Island on May 19, 2023, was among the most serious violations of the legal duty of care that a parent owes to their children that the Beaufort County court system had been called upon to adjudicate. The Bradley-Brun case also, inevitably and importantly, brings into focus the survival of the 8-year-old child who escaped. Her survival is documented in the court record not as a secondary detail but as a central fact, a fact without which the legal proceedings might have had a different evidentiary character entirely. She survived because she acted. She acted because, in a moment of unimaginable terror, she found within herself the capacity to do what needed to be done, to get out, to find help, and to make sure that someone who could call law enforcement knew what had happened. The legal system's response, the investigation, the prosecution, the conviction, the 50-year sentence, was initiated, at its origin point, by the courage and the quick thinking of an 8-year-old child. For child welfare professionals, mental health advocates, and legal scholars who have examined this case, the presence of 2 child victims in this case, one who did not survive and one who did, raises the full range of questions about what protective factors exist for children in situations of severe and escalating risk within a family home. How do communities identify children who are in danger in their own homes? What systems exist? In schools, in pediatric healthcare settings, in faith communities, in neighborhood networks, to notice when something is wrong and to act on that observation. What supports do children who survive experiences like the one documented in this case need in order to process what they have experienced and to build a path forward? These are not abstract questions in the context of the Bradley-Brun case. The 8-year-old survivor, whose name is appropriately protected by the considerations of privacy and child welfare law that govern the public discussion of juvenile victims, requires, as do all children who experience trauma of this magnitude, sustained, expert, compassionate support. The trauma literature is unambiguous on this point. Children who experience direct trauma, especially trauma of the kind documented in this case, benefit enormously from timely, ongoing, and developmentally appropriate therapeutic intervention. Communities committed to child welfare have an obligation not only to prosecute the adults who harm children, but to support the children who survive. Organizations across Beaufort County and South Carolina that work with child trauma survivors, including the network of children's advocacy centers that operate across the state, providing child-sensitive forensic interviewing, trauma-informed therapy, and case management services to child victims of abuse, were available to support the survivor in this case and to contribute to the broader community response that the Bradley-Brun case generated. Those organizations, and the network of professionals who staff them, represent the human infrastructure of child protection, the people who show up after the law enforcement investigation concludes and stay with survivors for the long, difficult, necessary work of healing. The death of the 6-year-old child at the center of this case, a child who was 6 years old, who had been in school, who had friends and family and the beginning of a full life ahead of her, is the permanent, irreversible fact at the heart of the Beaufort County prosecution. The 50-year sentence is the legal system's acknowledgement of that fact. The survival of her 8-year-old sister is, within the devastation of this case, the dimension that child advocates and community members have pointed to not as a resolution. There is no resolution, but as a reminder of the resilience that can exist even in the most terrible circumstances, and of the absolute necessity of building communities where children know that help is available, that escape is possible, and that the adults and systems around them will respond. The Bradley-Brun case closes this documentary not with a sense of conclusion, but with a sense of continuing obligation. The 10 cases documented here, across Charleston County, North Charleston, Horry County, Lexington County, Chester County, Beaufort County, and Union County, are 10 chapters in a story that does not end when the sentence is handed down. The story continues in the lives of the survivors, in the communities that must process what happened and commit to doing better, in the child welfare systems that must learn from every case they process, and in the ongoing work of every organization, every professional, and every community member who has made the protection of children their purpose. If you or someone you know needs support in connection with child abuse, domestic violence, or family crisis, please reach out to the Child Help National Child Abuse Hotline at 1-800-422-4453, available 24 hours a day, 7 days a week, 365 days a year. You are never alone. Help is always available. This documentary examined 10 cases drawn from the court records of South Carolina, presented in the spirit of responsible, educational true crime journalism, with respect for the victims and their families, and with the goal of contributing to the community conversation about child safety, accountability, and the work that remains to be done. Cold Case Hour is committed to covering these stories with the care, the depth, and the seriousness they demand. Don't forget to like this video, leave a comment, and subscribe to Cold Case Hour. Every subscription helps us continue telling the stories that communities need to hear. Hit the notification bell so you never miss a new documentary. We'll see you in the next one.